views matter.
Radio Zindagi 1170 AM per welcome listeners. Welcome to the Shah Peerally Law Show. Yes, once again we welcome Shah Peerally on air with us. He is the founder, president and managing attorney of the Shah Peerally Law Group, which is right here in Newark. He is a member of the American Immigration Lawyers Association as well as the State Bar of California. He is a passionate advocate of human rights, civil rights, social action and social services, and he has a strong interest in and knowledge of the political legal system in the U.S. He formed his law group to work on the causes that he feels most ardent about. The law group focuses on the immigration law with an emphasis on employment-based immigration, and Shah Peerally and his team helps clients all over the U.S. So listeners, you can also definitely get in touch with Shah Peerally and his team. Offices are in Newark, San Francisco and Washington DC. आप उनकी वेबसाइट पे जा सकते हैं अगर आपको ज्यादा इन्फॉर्मेशन चाहिए कि किन किन एरियाज में किन किन मैटर्स में शाह पीरली और उनकी टीम आपकी मदद कर सकते हैं. लॉग ऑन टू द वेबसाइट peerallylaw.com. That's PEERALLYLAW.com. इस वेबसाइट पे जाइए. यू विल गेट ऑल द इन्फॉर्मेशन. अगर आपको जैसे एम्प्लॉयमेंट वीजा, फैमिली वीजा, दूसरी सर्विसेज के बारे में पता करना है, कुछ आपको एग्जांपल्स चाहिए, यू वांट टू सी व्हाट द क्लाइंट्स हैव ऑलरेडी सेड अबाउट देम, टेस्टिमोनियल्स आप चेक कर सकते हैं. इन्फॉर्मेशन आपको कॉन्टैक्ट इन्फॉर्मेशन सारी मिल सकती है. उनकी वेबसाइट पर जरूर लॉग ऑन कीजिए peerallylaw.com. एंड इफ यू लाइक टू गेट इन टच विद देम ओवर द फोन, आप फोन कर सकते हैं ऑन 510-742-5887. वी ऑल्सो इन्वाइट ऑल ऑफ यू टू कॉल अस ड्यूरिंग द शो ऑन द स्टूडियो नंबर 510-657-1170. इस नंबर पे फोन करके आप कोई भी अपना सवाल पूछ सकते हैं, खास करके एम्प्लॉयमेंट बेस्ड इमिग्रेशन को लेके. कोई भी इमिग्रेशन का सवाल है, यू कैन डेफिनेटली स्पीक टू अस ऑन द स्टूडियो नंबर 510-657-1170. वी हैव अटॉर्नी शाह पीरली ऑन एयर विद us till 11 a.m. and in some time we will also be joined by attorney Sharif, who will also be talking to us till 11 a.m. So without any further ado, attorney Shah Peerally, welcome to Radio Zindagi.
Good morning. Thank you very much for welcoming me, Ara, and good morning to all the listeners. And of course, we're going to talk about immigration, and thank you for the introduction. And before I start, of course, the regular kind of disclaimer. Anything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And hopefully today, Ara, we're going to have Sharif joining me. We're going to talk a little bit about the visa jump, how it relates to the national interest waiver, EB1, etc. I think you had one question, Ira.
I did, yes. Yes, I did have a question. This morning it was in the news that the Trump administration, they have overhauled the H-1B visa program, which means the employers will be required to pay the high-skilled foreign workers, H-1B visa holders, working on significantly higher wages. So if you could also talk about this, what do you think is going to be, how is this going to impact the overall H-1B situation, considering that now it will be even more difficult for H-1B workers, H-1B visa holders to find, new or different jobs?
Yeah, exactly. This is. I just found out too myself about this, and it seems like they are going to increase the fees, but I mean not the fees, but
minimum wages.
Actually minimum wage. Well, it's not the minimum. Just to let people know, in order to, and most of our listeners probably know, whenever we file a case, we have to file the LCA, which is a labor condition application.
Right.
This is where we actually get the salary not the salary really there. We already kind of have an idea, but we get an approval by the Department of Labor that's on the minimum or whatever is prescribed by the level of the H-1B. It has like 4 levels. And now it seems like they are having a really, really kind of unprecedented increase in that level. And the thing is that it just seems like it's a lot of political move that is kind of sometimes counterintuitive where he's going. He tried to first to kind of quote the Indian voters, and now it seems like because the voters are not really in his favor, now he's going back. But what happened last week also is that he tried to increase the fees. The fees should have been increased by now, but by October 13th, but a judge blocked it. So I think this is going to happen again. Probably you're going to have a bunch of lawsuits, and you're going to have a judge block that law too. But unfortunately, until then, people who are filing their H-1Bs, they might be faced with a lot of issues. I don't have much details on it because I just learned it too, so I'm going to kind of try to talk about that probably next week and give people more details. But this is going to definitely affect a lot of people and companies if they have to increase the wages, because already we are in a depressed recession coming up, and in fact from all the studies, H-1Bs and immigrants kind of always help to bring back the economy.
Because the article that I also just now sent you, the one that I was reading and referring to, that is kind of demotivating, and it is pretty confusing, because it says that it will have significant, this change needs significantly higher wages. It narrows the type of degrees that could qualify an applicant, and also shorten the length of the visa for certain contract workers. And it also says that now it is expected that about 1/3 of the H-1B visa applications would be rejected under the new set of rules. So is this a proposal right now, or has this already been passed?
Well, this is exactly what I'm seeing, but he probably has been using the executive order to pass this. And again, like I said, I don't have enough information to know how much is this going to affect the H-1B. But I know also there's another rule that was signed by the president on October 1st. And in fact, it's still kind of confusing the way he signs stuff, and then the next day he changes it, etc., etc. Even the H-4, they were saying that it was going to have a premium coming with it, and now I'm not seeing it on the USCIS website. So until we see it on the USCIS website, I cannot give you additional information, because relying on secondary sources to give you the information is not right. I have to go to the original source, and that will take me some time to dissect it to give you the answers. But unfortunately, as you mentioned, there is a big chance that he's just trying to play some games, and it will be blocked again. The idea with him is, and again, it's my opinion, is that he comes up with something, pump up his base, and then suddenly you see he doesn't go through, but his base, they don't understand that actually. They're not very, unfortunately, not very knowledgeable about immigration, so they get the feeling everything is being done in their favor, which is nothing was being done against them, but they see it this way. So I mean, that's good enough to pump them up, and you see them. I get arguments, even people in our community supporting Trump. It's like when you argue with them, they will just speak louder than you with no argument, and or they will come with some kind of conspiracy theory that it doesn't even make sense sometimes. But unfortunately, we are dealing with a very a big group of people that really don't have any clue what's happening, and at the end of the day, they are voting, and they are voting based on many other factors than logic or rational. They are voting mostly based on, some of them on religion, or some of them based on really wrong stuff. So we'll get that information soon for you guys, and I will post it probably also soon on YouTube or something. But next week we'll talk a little bit about more details. But by next week it might be gone, by the way.
Right now we have a caller. Let's speak to them. Let's see what they have to ask you. Meanwhile, I'll also get Attorney Sharif on the phone. Hello, you're on air with Attorney Shah Peerally.
Hello.
Hey, Shah. I have a question regarding this new date advancement for EB3 and EB2. So.
Yes. Go ahead.
Hello.
Yes. I'm listening to you. Go ahead.
Yeah. So my priority date is September 2012 in EB2, and I see that pretty much many of the folks are converting, downgrading to EB3. So do you think that EB2 may get advanced in like next couple of bulletins, next couple of months from like which is there right now for May 2000?
Okay, I think I lost the caller, but let me answer the caller.
Meanwhile, we also have Attorney Sharif on the phone with us now.
Okay, great. Let me answer the caller and then we'll take Sharif. Yeah, I think EB2 will move forward, by the way, but I don't know how much it's going to move forward for. So if you're getting a chance to downgrade to EB3, we're telling people to go ahead, especially if your dates are fall. But again, what we think is that we might just see filing dates, no real final action rule, which changes the whole dynamic, which means you can actually file for the adjustment of status, EAD, etc., but not really get a green card. So it is worth it to downgrade, but if your dates are closed, then wait for the next visa bulletin, which will come up probably in 1 week or so, and then make a decision. Or give us a call, 510-742-5887. Sharif, are you there?
I'm here, Attorney Shah. How are you doing?
Okay. Assalamualaikum. I'm doing well, my friend. So I wanted to check with you how things are going, and you know what has happened on the EB3, and a lot of people are jumping on it.
Yeah.
But at the same time, they should know that this is not really the final goal. It's just a little bone that was thrown at us, fortunately and unfortunately. So we need to be careful. We have to have backup. So today I'll have you to talk a little bit about basically pushing for an EB1 and EB2, because EB3 is just hanging there. It's giving an EAD, but it's not giving a green card.
We have two callers over here, so whenever you're ready, we could take them on air.
Okay. Yeah, before we take the caller, if I could just chime in.
Go ahead.
I think one thing that we've been saying all along to the listeners and our clients definitely is we need to take an all-of-the-above approach, meaning if you are in a situation where you've been in the backlog, you've been in the U.S. for, maybe close to a decade now, and you are in the, wait time, or you're in the queue for a green card, and somehow we just need to be logical and think about the math for a second. So if we downgrade into an EB3 scenario, how many of those EB3 areas, how many of those EB3 visas and adjustment of status do we think they're going to allow to be completed? And how is that going to move the, overall calendars and priority dates? It is very, very unlikely that you're going to see massive amounts of green cards issued under an EB3 category when many people are downgrading from EB2 to EB3. However, on the other hand, the positive side is that having the ability to file your adjustment of status will likely mean that you will be able to get an EAD card. So that is really a plus, and that is why we are encouraging people to do the downgrade and file the adjustment of status. But I want you to be realistic and understand that you still need to think about how we can, basically port you to an EB1, or what is an all-of-the-above scenario such that perhaps you file a national interest waiver under EB2 as you go down into the EB1 scenario. So there are, different options there we need to consider.
Awesome. Great. Thank you, Attorney Sharif, for that. We have a caller who's on hold. Let's take this call and then let's continue talking after that. Hello, you're on air with Attorney Shah Peerally and Attorney Sharif.
Hey, okay, so, hey, can you hear me?
Yes, I can hear you loud and clear, sir. Please go ahead.
Yeah, so my question is, my spouse is on F1 and her STEM OPT EAD is expiring June next year. And I have an approved I-140, so worst case, she can come on H4 EAD. So I wanted to ask, should we wait for the lottery next year? It's going to be her last chance, or just preemptively do a change of status right now to an H4 EAD?
Well, the H4 EAD is taking some time. Unless this premium rule really comes true, it might be a good idea to start the H4 EAD now. Hopefully she gets on the H4, and by that time she gets on the H1. But the advantage of keeping her on the but she has a STEM OPT, right? So it's expiring next
till June next year.
The cap gap might not work exactly right. So if you can start the H4 EAD, or the other option, don't do anything, and then when it's closed, if you want to get an H4 quickly, you can just leave the country and then come back on H4 and then file the EAD. It's very hard to give you a general answer. It's a case-by-case basis depending on your needs. But I will recommend to start looking in the EAD as soon as possible, because it's taking some time to get it. Unless we have this rule that everybody's talking about, and I need to confirm that H4 has passed into premium now, they allow that. So we need to check on that. But bottom line, the answer is probably yes, but we have to double check what are the circumstances, if it is a good idea for her to jump on the EAD or just use the OPT and then next year decide how things go on the H1. But the H4 EAD is a lot more flexible than the H1. So personally, I'll prefer to use an H4 EAD than an H1.
Okay. Just another quick yes or no answer. Like, if her H4 change of status is pending, can we travel to Canada?
Well, you can travel, but then it will stop the process. But the good news is that if you're planning to travel anyway, just get the stamp in Canada and come back. That's all. Okay, then you don't need even the pending here, because H4 doesn't require an approval here to get it there. Okay?
Thank you very much, and good luck. If you have any more questions, you can actually get in touch with Attorney Shah Peerally and Attorney Sharif. Call the office number 510-742-5887. That's 510-742-5887. Get more information on the website peerallylaw.com. That's PEERALLYLAW.com. peerallylaw.com. Yes, Attorney Shah, Attorney Sharif, let's continue our conversation.
Yes, indeed. Sharif, tell us a little bit about one thing people I just wanted to insert here is like people who are moving to EB3, they are kind of basically taking a gamble, especially if they are downgrading. And now going back on EB2 might be an issue if you have to file the I-140. And also, what happens is that let's say you're eligible for AC-21, you move from company A to company B, and from company B you won't be able to go back to EB2. So one of the options is to have a national interest waiver by your side. That means if EB2 becomes current and final action, you can just shift that I-485 to that EB2. And that's very interesting, because that national interest waiver will always move with you. Right, Sharif? I think that's a good thing.
Exactly. That is what the all of the above approach is all about, is to, if you are indeed going to file an adjustment of status under EB3, it is absolutely, necessary, in my view, then, to preserve your EB2. As you know, you cannot have an EB2 and EB3 at the same time with the same labor. So having that national interest waiver, and a lot of folks do qualify for the national interest waiver. So that is something that is absolutely in folks' interest to do that. So I would sincerely advise people to look into a national interest waiver as they do this, because, I've come across many people who, for example, maybe they have a priority date back in 2009 or 2010, and the bulletin maybe came current for 1 month, way back when, maybe 10 years ago, and they filed their adjustment of status, and then, of course, it retrogressed again, and they've been sitting on an I-485 pending for, 8-9 years. This is not unheard of. We come across these all the time. So,
I had many clients like that, actually.
Exactly. So, if you are filing an I-485 under an EB3, again, we are encouraging you to do that, because you will, in all likelihood, get the EAD card, but it's not going to solve all your problems, unfortunately.
Exactly. And what I'm expecting, unfortunately, And I'm not sure, so I don't want to tell that to my clients, but we can say it on the radio what we think. We're guessing. It's all a political move. We know that because this could have been done a long time ago. It didn't get done, and it is done right now for whatever reason, and we kind of figure it out. It's more like to quote the Indian community. But at the end of the day, they might never bring it to date on the final action date. And for people on final action date is very important because that's when you get the green card pretty much, start getting processed. And the final action date also protects your children sometimes with the Child Status Protection Act. But the final
I
date
can add a degree of skepticism to that. If you think about it, so at the same time as this bulletin, so what did the USCIS do, right? They allowed the State Department's initial filing date to be the basis for one to file an adjustment of status. So they did that with full knowledge that obviously you're going to get a huge amount of folks filing their adjustment of status. At the same time, they were anticipating increasing the fees on October 2nd. Now, while that was struck down by federal court in terms of the fee increase, they were not anticipating that to be struck down. So that fee increase was struck down. But it is very, very interesting that the ability to file adjustment of status, right, coincided with the exact date of the fee increase. So, and if you have, this massive number of adjustment of status and EADs, because remember, if that fee increase were to go through, there was a separate fee for the EAD, separate fee for the advanced parole, in addition to the I-485 fee. So you're looking at a huge windfall to the coffers of the USCIS, and they have been, kind of trying to increase their revenue there. So this, I think, not only was a political move, but also was a financial move in terms of, basically bringing in those fees. And the most recent financial move was sort of unrelated to that, because that was a fee increase that was passed through Congress in the most recent government funding bill, which expanded the number of cases for which premium processing may be available, and also increased that fee from $1,440 to $2,500. And then the other change with respect to premium processing is it used to be 15 calendar days. Now it is going to be 15 business days. So that's 3 working weeks. So we do see those changes. But again, just going back to the point, I agree with you that this certainly is a political move, but I'd also say it's a financial move to a large degree as well.
Exactly, and we know what's going on. Then I understand, and I think people should take advantage of it, of course. But at the same time, you have to have your backup. For example, if you have a husband and a wife, EB2 both, don't downgrade both. Keep the one. And what I recommend is downgrade the higher end one, which is the date that will take longer. Basically keep the one which is closest to the regular date, because EB3 will keep progressing now, but it will progress at a lower rate, but at least it's going to be steady, or what I would think. And there's a chance there will be a jump on EB2, because a lot of people will be jumping from EB2 to EB3, not now, in a couple of years. So you need to look into that, and that's one of the things we wanted to discuss today about the national interest waiver. In fact, we're getting a lot of calls of national interest waiver because, as you know, Sharif, once you file the adjustment of status, 180 days has passed, and you move to a same or similar position, the entire case can move from one company to another. Having said that, now, if you have a situation like that and your EB2 is with another company, you won't be able to upgrade back to using the same labor certification, because that labor certification pretty much belongs to another company. So in this case, a national interest waiver can really be important. Now, if you qualify for EB1, which is the perfect thing, because a lot of people believe they don't even qualify for EB1, or the EB1 was wrongly filed and they get a denial and they just give up. We had a bunch of clients like that, and they came to us and we were able to fix that. And at the same time right now, EB1 also progressed. And EB1, the advantage is that you pretty much kind of a self-petition. You're not at the mercy of an employer. So people should also take advantage of that, right?
Absolutely. Absolutely. In both cases, I think the national interest waiver and the EB1, the great advantage of them is that you are not at the mercy of the employer. You can self-petition. Folks who are filing now in EB3 and even EB2, one thing you have to understand is when you file that adjustment of status, I-485 application to adjust status for a green card, permanent residency, you are also filing what's called a Supplement J, which is the employer's verification of the job offer. And that means that, you are at their mercy still as long as your I-485 is pending. For our cases where we have, many times gotten the approvals on the EB1A, the individual filing the I-485 after an EB1A approval does not need a job offer, does not need an employer to tell them anything. I mean, you are completely and absolutely a free human being at that point. So there's a huge, huge qualitative advantage between having a self-petition, either an EB2 or EB1, versus, having an employer-sponsored petition where ultimately the employer will continue to pull the strings until, that green card is in your pocket, which, as we know, will definitely take a very, very long time, even with the latest changes. The other point I think worth noting, I guess, is that there is a difference between the State Department Bulletin and the Adjustment of Status Bulletin that USCIS uses, right? So we have the State Department Bulletin that provides the initial filing dates and the final action date, and then a separate, within that even website, there's a link where you click and you go to the USCIS Bulletin. Now, the USCIS Bulletin is based on the State Department Bulletin, but they will, from time to time, switch between having the adjustment of status date based on the initial filing date or based on the final action date. Now, obviously for October, what they did is they based it on the initial filing date. Now, I would honestly suspect that may change in the coming months. So I don't know, Shah, what you think about that, but most of the time, USCIS will use the final action date as the adjustment of status date. Right now, they're using the initial filing date. So any kind of insight there?
Yeah, basically what has happened, because under Obama, when they initiated that new rule of filing date and final action date, it was to encourage the filing, and it has kept this way. And then in 2017, under Trump, of course, everything got upside down. They started refusing to accept that. But ultimately, there were a lot of kind of push by companies, etc., and they agreed, because they were supposed to accept the filing date, and they did. And I think they will probably continue doing that. But with them, you never know right now. Things are so hectic. But one thing which is very interesting that people don't also... a lot of people are looking at their dates and say, hey, for example, right now it's January 2015, and they say, okay, that means in few months mine will be current. It doesn't work this way exactly, okay? Yes, it might, but there's a big chance it will go completely backward too once they get the number of applications they want. And when this happens, that means if you don't take a chance, you lost the chance. I'll give you an example. This morning I was speaking to one, without giving any information on that person, one person who consulted with us almost 1.5 years ago. and then he backed off on the EB1, and for whatever reason he tried it with some other lawyers and they failed, and ultimately that person now is finding himself having no I-140 at all, cannot extend the H-1B or anything, and I know because when we look at the case was really a strong case. So these kind of things, unfortunately, is not really kind of it's not really kind of, you're losing a chance, because if your dates are not current right now, it might get current, you never know. But EB1, from my experience, I've been doing this now for 17 years almost, it's always been not that much for India. In fact, it was current for years and years and years. It just recently, I think 3-4 years ago, it started going backward a little bit. But still, EB1 has been doing well. I think right now we are in 2020, if I'm not mistaken, right? So on filing, so EB1 is the way to go if you get a chance to get in. It's not impossible. You might qualify without knowing it, but with all the advantages of choosing an EB1 over an EB2, etc., I would highly recommend people to check on the EB1, and it costs nothing, at least one consultation. We can go ahead and assess it for you. And that's
right. And you know, sorry, I was just going to say, you know, we have joked that before 3 or 4 years ago, you know, all of the EB1 for India was under EB1C, until, you know, we started doing the EB1A ourselves, and then it, you know, started getting backlogged. So it's probably because we have so many EB1A approvals that it's making a backlog there, even in EB1. But you see now that was a good one as well.
Yeah, that's true. I think we have one caller, Sharif. Let's take the caller and then we'll continue.
Okay. Oh, I think his call got dropped. But listener, if you're still there, if you would still like to ask a question, call us right back and I will take your call directly on air, and you will be able to ask your question to Attorney Shah Peerally and Attorney Sharif. Call us right back on 510-657-1170. Let's take this call. I think he's back. Hello, you're on air with Attorney Shah Peerally and Attorney Sharif.
Yeah, hi. Can I talk to Shah?
He's here. He's listening. Please go ahead.
I'm listening. Yeah. Hi. Thank you for all this advice. I have one question. My wife's name in birth certificate has a typo.
I'm sorry, your wife's name in the birth certificate has a typo. Is that what you said?
No, marriage certificate.
Marriage certificate has a typo. Okay.
Yeah. So just one letter is instead of V, they put W. So is there a way I can, do I need to do affidavit, or is there a way I can get it fixed, or is it okay to have it like that?
Okay. Well, if it is a marriage certificate, it's not a big thing. What I will recommend is that you put a declaration in there explaining that this was a typo. Instead of a V, they put a W, or vice versa. And show other documents that shows that's her real name. And they will probably accept it if it is one letter. If it is, and if there are any changes there, just mention it also under other names. And if there are any bigger issues, then they will request something. And if you want to put an affidavit, you can go ahead and do an affidavit from someone who attended the marriage, and that's her name, etc. But it's not that major. You should not be worried.
Okay, got it.
Okay.
Thank you.
Okay.
Thank you very much for calling in. Listeners, if you also like to have any questions, you can get in touch with Attorney Shah Peerally and Attorney Sharif on the office number 510-742-5887. 510-742-5887. खास करके एम्प्लॉयमेंट बेस्ड इमिग्रेशन को लेके आपको अगर सवाल है, या कोई भी अगर आपको इमिग्रेशन के बारे में सवाल है, कुछ भी आपका केस है, and if you have a point, then you'd like to get in touch with them. 510-742-5887. Get more information about their practice on the website peerallylaw.com. That's PEERALLYLAW.com. Yes, let's continue.
Yes, Sharif. Tell us a little bit about what you're getting, because a lot of people are confused. You know, they're seeing the easy way, they're taking it, which I think is, of course, is good, because hey, why would you let the chance go? But at the same time, one of the biggest things they have to understand is that the visa bulletin is not a progressive unit. it goes forward and it goes suddenly really backward, especially when it has this jump. We experienced that in 2007 where everything got current suddenly. And then few months after that, we saw EB3 getting stuck to 2008, and that's it. It was like that for years and years and years. So I tell people you have to be careful because especially if you're not in the line right now, I'm thinking it will stay there for a little bit right now, for like 4 or 5 months probably, but after that we're going to see a retrogression, probably on EB3. As for EB2, it will continue moving slowly probably, and also at one point it will have a retrogression. So I think it is important that people understand that how the visa bulletin works. There's no real genuine science behind it because they've never really been transparent about it. But But bottom line, it is important that you all kind of make sure that you get a chance to take the chance, like you say, take all the approach, and few of the things that they have to look into, the EB1 national interest waiver, and also a lot of people look into EB1C. Let's talk a little bit about EB1C, Sharif, because a lot of people they are undecided because they are tired. They want to stay, for example, in Canada, spend 1 year. Tell us a little bit about that.
Got you. So, I think that definitely right now in the EB1 category, there's great opportunity because the number of EB1C petitions because of the corona situation and coronavirus and Trump's kind of restrictive policies has really opened up opportunity. So there are a lot more EB1C visa types available in that category. So those people who have the ability through their employer to maybe take 1 year, perhaps work overseas or outside of the United States and Canada, the requirement for the EB1C is that you work in a managerial or an executive capacity for an organization that has an affiliate or a subsidiary or parent relationship with another company. And this could be inside of this could be, again, in Canada, it could be outside, must be outside of the United States. And they spend at least 12 months at that organization. So you could either be outside of the U.S. presently, work a minimum of the 12 months preceding your entry into the U.S., or if you're in the U.S., obviously, you'd have to leave work in an executive or managerial capacity for a minimum of 12 months for an organization that has an affiliate, subsidiary, or parent subsidiary relationship with a U.S. company, and ultimately return, and that would allow one to file in the EB1 category. And, a lot of people think, well, manager or executive, what really, is my role? That is some flexibility. So, for example, one such area of flexibility is called a functional manager. So a functional manager is an individual that manages a particular part, a particular organ of the company. So, for example, like a sales manager, if you're in charge of the sales, or an engineering manager, for example, it doesn't necessarily have to be that you have a large team of professionals that are reporting to you if you are managing a function of the business. Now, we also have seen many cases where a more closely held company may want to expand into the U.S. So you have you can start that journey using what's called the L1A, which is similarly a manager or executive visa, but this is a non-immigrant visa. However, it does allow for dual intent, so you can basically enter the United States on an L1A visa, and then after a period of time when that business is more established, you can file for your EB1C. So again, this is a really great pathway and does allow somebody to really take advantage. So, for those people who have that ability to take the position and then return, that is one area. And a lot of people have taken advantage of it and done it. because you definitely want to get yourself in the EB1 category, whether it's through executive or managerial category, or as an individual of extraordinary ability, which, obviously we have spoken about before and we could touch on again. Now, we did also earlier in our conversation mention the national interest waiver several times. So I think for people who maybe are just hearing that terminology and don't quite know what it takes or what it is, maybe we can also enlighten those listeners.
Yes, indeed. And I don't know if we could hear you properly, Sharif. Ira, could we hear him properly? Because I kind of...
I could hear him fine, yes.
Okay, perfect.
Okay, great. So let me just, if I can, just explain to folks what the national interest waiver is all about.
Mm-hmm.
So those of you who are presently in the U.S., or outside the U.S., but just to target kind of the group that we are looking at in terms of those who are on the visa backlog and are thinking about downgrading to an EB3 and filing a concurrent adjustment of status, one huge way that you can protect your interest is by filing a national interest waiver. Because what will happen is if your dates, if you downgrade to EB3 and then later on your dates for EB2 become current, you don't want to put yourself in a situation where you're depending on the employer again to, refile your I-140 in EB2. Instead, you can be self-reliant. So a self-petition national interest waiver is an EB2 category visa. It requires either a master's degree or a showing of certain extraordinary abilities. So for those who have a master's degree, it is definitely an easy pathway to get to a national interest waiver. If you do not have a master's degree, then you need to show 3 certain criteria. Now, those are not that difficult of criteria. For example, one such criteria is that you have a bachelor's degree. Another is that you have 10 years of professional work experience. And, others would be like professional membership in an organization, that you command a high salary, that you perform in a critical role, that you have original contributions of major significance. So these are alternatives to having a master's degree. So once you get over that hump from the national interest waiver perspective of either having a master's degree or meeting those criteria that I was mentioning, then we look at whether you are working in an area of national importance. And again, this is an area where we're pretty flexible and have been able to show national importance in a number of different examples. So that you work in an area of national importance and that you have, that requires substantial merit. So you work in an area that is, so this is not about you personally, it's about the area of work that you're involved in. For example, if you're in the data sciences realm, we could certainly craft something there, and that it has substantial merit to it. It is somehow important and requires one to be have a certain caliber of abilities. The second part of the analysis is that you are personally well positioned to advance that particular area of endeavor. And then the third is that we do a balance test, because a national interest waiver is the waiver from having your employer file the labor certification. So therefore, we need to explain to the officers why we do not need to have a waiver in your particular circumstances. And again, this is based on the national importance of your work, where you stand within that field. So it is some, basically there is a lot of flexibility in this area of law, and I would strongly suggest that anyone interested in a national interest waiver have us take a deep dive into your profile and determine whether you would qualify for that criteria.
Exactly, and the thing is just like the people have been shying away from those EB1 and national interest waiver. In fact, most lawyers do shy away because they think it's like almost impossible. Only the top 5% of people qualify, which is not really true. The truth is that many people do qualify without even knowing them. knowing that they are qualified for it. And that's where we come in. We can at least assess the situation, and we'll tell you. If there's no chance at all, we'll tell you up front, because it will be bad for us to kind of take the case just for the fact of taking the case. And that's the reason that we do that assessment, both me and you, before we move forward. And one of the things, tell us a little bit about the situation right now on the approvals are still coming fast on the premium for EB1, right?
Absolutely, yeah. We do see lots of success on the EB1. It's been very consistent, I have to say. A lot of people, complain that, they're always seeing increase in RFEs, and definitely they have been increasing the RFEs, especially for like H-1B and H-1B transfers. But for the EB-1 category, I think there's a recognition within the government that the highly skilled folks are going to be needed within the U.S. And when we make our case, it is so powerful that, it kind of puts them in a situation where they can't refuse it. And so that is always our approach in terms of EB-1, is that you need to put the government in a position where they have to approve the case, where you meet all of the statutory requirements. And I would say the biggest challenge for a lot of people in terms of EB-1A is that they just want an easy, quick situation. And, there is no easy, quick result, right? It always takes hard work. It always takes, you to kind of roll up your sleeves. It is a considerable amount of work on our end, and it's also a considerable amount of work on the client to gather all of the evidence and to really put forward a strong case. So you have to, but you know what? It's also a very rewarding experience. I cannot count the number of people who have thanked me not only for getting their EB-1A approved, but also for changing their life by going through the EB-1A process. Remember, you're going to have to join certain professional organizations that require outstanding achievement of their members. Well, we're going to point you in the right direction. It also requires
as a
that you have reviewed.
Let me interrupt you, Sharif. We had a client, someone called last week. He was so happy. He wanted to call, and he mentioned that he didn't believe when we told him we could get it done, and he was very happy. So just wanted to add that as a footnote.
Yes, thank goodness. And those stories, there's so many of them. I mean, not everybody's going to call the radio show, and he was so nice to do so. But every single day, people are definitely thanking us personally, and we're really changing their life, because what happens is not only are you, joining these professional memberships that we're pointing you in the right direction, one of the requirements for EB-1A is that you continue to work demonstrate that you'll continue to work in your fields of endeavor. So what does that mean? It means that you show the government that you're in high demand. So what I always encourage people to do is put themselves out there. Maybe upgrade your LinkedIn to a premium, and maybe put that you are interested in various positions. Maybe, send out certain, feelers out to different HR departments and see what kind of interest that people have in your talents and abilities. I remember one such case where the person was actually doing that, and she got a job offer $65,000 more per year than her current position. So, just going through the process just develops so much growth. And a lot of people kind of realize how much talent and strength that they have going through the EB-1A process, because, there are so many things that we're able to open up in terms of, our thought process and thinking outside the box versus taking a very kind of, minimalist approach, But again, I think a lot of times the people, maybe they're in more of a hurry and they just want to submit it really, really fast, and they think that they have all the evidence. But those people might struggle. But those people who have a great level, of intelligence and trust us, they're pretty much always successful. I would be hard-pressed to find clients who were patient, who followed our direct instruction for how you get an EB-1A approved, and they were not successful. And honestly, I don't care what your profile is. A lot of it is just what is your willpower? What is your strength? What is your ability to meet the qualification and to get the evidence that I tell you to get? I mean, obviously, you're going to need a certain level, but ultimately, even those who might be a rocket scientist will fail if they don't provide the proper evidence. So you have to think about it that way. It's ultimately the evidence is what tells the story.
Mm-hmm. We have 3 more minutes to go, Sharif, so give us some closing argument, and just to let people know if they need help, give us a call, 510-742-5887. And also we have a YouTube channel, youtube.com/Shah Peerally Law. Subscribe to it and we'll give you updates as much as we can. So Sharif, what are your final take right now? I think people should focus on the National Interest Waiver because it's not an easy pick, but it is going to give them a good backup if they don't qualify for EB1. What do you think?
I 100% agree. I think those who are doing the downgrade to EB3 and filing the adjustment of status are basically, doing themselves a great disservice if they don't, at the same time, look into filing a national interest waiver. I mean, you may not qualify, who knows? But ultimately, at least determine, look into it and see what the qualification is and whether you would be a good candidate or not. Because, I mean, we have been getting EB1A approvals for data scientists, for people who are, working in the consulting world and implementing, important projects. So trust me, we can definitely get national interest waivers done. I would say if EB1A is a journey of maybe, many miles, then a national interest waiver is a pit stop along that journey. Because, it is the requirements for a national interest waiver are far less stringent than the EB1. So it is definitely one that a lot of people qualify for. They may just not know it. So, let's hope the, backlog goes away completely because I think with a national interest waiver, we could definitely help so many people who want to immigrate to the U.S. It is a very, very beautiful tool within the employment-based arsenal, and one that we're definitely well equipped to take advantage of. So those of you out there who are doing the downgrade, make sure you think about filing a national interest waiver. Very, very important.
This is an interesting point you just brought up, Sharif, because a lot of people from different countries like Afghanistan, Pakistan, Nepal, Sri Lanka, and everybody, Fiji, they listen to our shows. And people don't know that you can file a straight green card, come to the U.S. I've done it many times where you don't have to be in the U.S. to file that. You file it, you get it approved, you process it to the U.S. consulate, and you come here. We had a lot of clients. I have few clients, not a lot, but few clients who did exactly that. Especially I had clients from Romania. I had some clients from, and one client, he was from India, but his wife was born in the Middle East. So we used that date and merged it, and they were able to come directly from Dubai to here on a green card. So people should consider that. Having said that now, Sharif, I think we have not much time left, right, Ira? We have another 30 seconds.
That's right.
I wanted to thank all the listeners. Anything we told you today is our opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. 510-742-5887. Thank you very much, Sharif. We'll be back next week, same time. And hopefully we will hear from people and if you need help again on everything immigration, feel free to call. Thank you. And Ira, I don't know how much time, I didn't check, but I think we are done now.
Yes, we are.
Thank you, guys. I appreciate it.
Thank you, Attorney Sharif. Thank you, Attorney Shah. And listeners, definitely get in touch with Attorney Shah Peerally and Attorney Sharif on their office number 510-25887 for everything immigration. And they will be back next week, same time, same place. Meanwhile, do remember to log on to the website, peerallylaw.com. That's PEERALLYLAW.com. This is Ira signing off. You have a beautiful day. Cheers.